line 7 on page 3 be amended by A, replacing in quotes, whereas Parliament recognizes the importance of the privacy and data protection principles contained in various international instruments, end quote, with the following, whereas Parliament recognizes the importance of privacy and data protection, end quote. And B, replacing, quote, whereas the processing of personal information and data should respect minors' privacy and their best interests, end quote, with the following, quote, whereas minors actively take part in the digital and data-driven economy and their personal information is worthy of stronger protection given their varying levels of capacity to understand how it is used by organizations and the potential long-term implications of such use, end quote. And C, deleting the following, quote, whereas the design, development, and deployment of artificial intelligence systems across provincial and international borders should be consistent with national and international standards to protect individuals from potential harm, end quote. D, replacing, quote, whereas Parliament recognizes that artificial intelligence systems and other emerging technologies should uphold Canadian norms and values in line with the principles of international human rights law, end quote, with the following, quote, whereas Parliament recognizes that emerging technologies should uphold Canadian norms and values in line with the principles of international human rights law, end quote. Thank you, Chair.
Thank you, Mr. Turnbull, and I believe colleagues have all had a written copy of the sub-amendment referenced 1299-1258 by Mr. Gahir, moved by Mr. Turnbull. So we'll now open debate on the amendment proposed by Mr. Turnbull, sub-amendment. Mr. Viss.
Thank you, Mr. Chair. Thank you to our officials for being here today. Again, I was a little I'll start with my notes, I guess. In the last meeting, I did introduce conservative amendment CPC 1, which would amend the preamble to include the fundamental right to privacy and include text that would state the processing of personal data should respect minors' privacy and their best interests. This sub-amendment clearly deletes the best interest clause. I will note in good faith, later on in the amendment process, there is universal agreement on the fundamental right to privacy. So my real concern here is the second phrase that's being deleted, and that's respect minors' privacy and their best interests. So I put forward this amendment, as it was one of the key recommendations tabled by the Office of the Privacy Commissioner. In the Office of the Privacy Commissioner's submission, they recommended that in addition to putting in a fundamental right to privacy, which I think there's unanimous agreement on at this committee, the preamble should also reflect the importance of protecting children and minors. Jurisdictions around the world have recognized that children and minors may be impacted by technologies differently than adults, be at greater risk of being affected by privacy-related issues, and therefore require special protections. I think there's broad unanimity at the committee that is the case too. The Office of the Privacy Commissioner said that updating the preamble in such a manner would encourage organizations to build privacy for children into products and services from the start and by design. And since Canada's privacy laws were designed to be technology neutral, this would help ensure that the best interests of children would be considered for new and emerging technologies and for future uses of data. Adding the proposed language to the section that frames the legislation's intent would help ensure that the best interest of children and minors are prioritized and consistently considered across all related bills. I believe that the law should recognize the rights of the child and the right to be a child. Taking in the concerns of the pushback on this language from the government and some of the comments made by you, Mr. Shen, at our last committee meeting, I did host a meeting with the Privacy Commissioner yesterday, asking him to further emphasize the importance of including this language with C27, and I will note that Mr. Massey did join me at that meeting. In having this important meeting, the Commissioner gave some key insights as to why it is crucial to keep the best interests of the child language within the preamble. So my first question to you, Mr. Shan, in the last committee meeting, we heard that the term, the best interest of the child, was a subjective construct. In speaking with the leading experts in this field, I have to say I don't agree with your interpretation and and the way you phrase that term. So can you provide us the legal opinion that led to you making that statement on behalf of the department at the meeting?
Thank you, Mr. Chair, for the question.
Microphone, please.
For regulations with that? Oh. There we go. Thank you, Mr. Chair, for the question. The drafting process for amendments considers both policy and legal considerations. And so our recommendation that best interests might be less interpretable than particularly the capacity indications that we've indicated in the government amendment is a mixture of those. And so I'm not in possession of a legal opinion that I'm able to share with the committee.
In my discussion with the Privacy Commissioner yesterday, he referenced a couple of existing case law in Canada that he said related to the best interest of the child. In fact, he gave me a couple of examples where the best interest of a child was included. The first example is the case of K.M.N versus S.Z.M 2024 BCCA 70. The BC Court of Appeal allowed an appeal by a mother because the trial judge failed to conduct a proper analysis of the allegations of family violence by the father. The court, in this instance, recognized that the best interest of the child is of paramount importance in family law matters. This new judgment clarified that it is not sufficient to limit the best interest of the child analysis to evidence of violence specifically directed towards the child. In 2015, we can also look at the 2015 case at the Supreme Court of Canada, Canthasamy versus Canada. In this case, the Supreme Court of Canada considered the best interest of the child and made a decision in the context of an application for permanent residence on humanitarian and compassionate grounds. It held that the decision makers, that being the Department of Immigration in this case, must identify, define, and examine the best interests of the child and consider them in view of the other relevant factors. Best interests of the child, in my opinion, is not a subjective construct. Provinces across the country have the best interests of the child written into many laws. Here is a list of the references where the best interest of the child is used in Manitoba family law, in BC family law, Alberta family law, Nova Scotia family law, Ontario family law, Northwest Territories, Prince Edward Island, Newfoundland and Labrador, Nunavut. But I just want to get down to that. Why would you say that it's a subjective construct when it's clearly a defined term that's used in the Canadian legal system already?
Thank you, Mr. Chair, for the question. And I appreciate the references that have been put on the record. I'd note that they're all in a family law context, and what we're at issue here with is the construct of the best interests of the child from a commercial context, given that we're talking about the commercial application of personal information in a transaction between a consumer and a corporate entity, for which those family law constructs are well understood in custody and various other family law contexts, but are not jurisprudentially established in a commercial law context.
Mr. Chair, I would also point out that the Canadian Bar Association has a document outlining their perspective on the best interest of the child, and they state, I'll say point number one from the Canadian Bar Association, and I don't believe this is reflective just of family law, but they said that the best interest of a child is a substantive right, and it should be a primary consideration in actions concerning the child due to a child's dependency, maturity, legal status, and often being voiceless in society. Second, the Canadian Bar Association outlines, in respect to the best interest of a child, that it is in fact an interpretive principle. If a legal provision is open to more than one interpretation, the interpretation which most effectively serves the child's best interest should be chosen. Thirdly, the Canadian Bar Association points out that the best interest of a child refers to a rule of procedure, legal representation, timely decisions, reasons for how a decision is reached, how factors were weighed, and how a child's view were considered. And I'd say fourth, the best interest of the child, according to the Canadian Bar Association, in their mind, is a substantive right and a guiding principle that covers the conventions on rights of the child, which is aimed at the child's holistic development and requires a rights-based approach that promotes the child's human dignity, adult judgment, and I don't believe this is subject solely to family law, cannot override a child's rights. So I will also point out that I did a quick analysis by the Library of Parliament, and they have a whole number of examples that where a child's best interest lie, and it actually goes beyond family law. It also relates to the treatment of Indigenous children. For example, an act respecting First Nations, Inuit, and Métis children, youth, and families. And numerous other cases that I'd be happy to share with the committee. That was done very quickly, but I did get that from the Library of Parliament. They gave me 50 different examples where the best interest of child is in Canadian laws, both at the provincial and federal level. So with that in mind, last year, the privacy, I'm just going to say that in response. So my next question would be, last year, the privacy commissioners across the country all signed a special resolution of the federal, provincial, and territorial privacy commissioners and ombuds with responsibility for privacy oversight, which specifically highlights putting the best interests of young people at the forefront of privacy and access to personal information. Mr. Shand, do you agree with the use of the term the best interests of the child in the joint declaration of every single privacy commissioner and the Canadian Privacy Commissioner when they put out that declaration in October of 2023?
Merci, Monsieur le Président. Je suis...
Thank you, Chair. I agree with the sentiments expressed by privacy commissioners. We were looking at ways of protecting the interest of children.
I'm not at all at odds with the directional push from privacy commissioners to ensure that there are appropriate protections in place for children.
The privacy commissioner, along with every single territorial and provincial privacy commissioner in Canada, considered putting the best interests of young people at the forefront of this law. And I'm at a loss as to why the department, Mr. Chair, does not want to include the very language that our privacy commissioners at the provincial, territorial, and federal level of government have signed and requested we do in the documents that they unanimously agreed to. In those documents, putting the best interest of young people at the forefront of privacy and access to personal information, it's about building in a child's right to privacy by design. It's about being transparent. It's about setting privacy protective settings by default and to turn off tracking and profiling. It's about rejecting deceptive practices, limiting the disclosure of personal information, allowing for deletion or de-indexing and limiting retention, and facilitating access to and correct of personal information. All of you can find this document on the Privacy Commissioner's website. It was right on there. And again, I'm still at a loss from what I've heard today from the department officials as to why they would say this is a subjective construct. Ms. Denham, in response to the testimony from the last meeting, wrote to me And she said, and she was the former Privacy Commissioner of British Columbia and the former Privacy Commissioner of the UK, where they embedded the best interest of a child into British statute law. She stated, and I quote, "I remain supportive of the Conservative amendment in the preamble. The best interest of the child is a legal test, not a construct, but a legal test used to decide what would be best to protect a child's physical, psychological, and emotional safety, security, and well-being. It is defined in the UN Convention on the Rights of Child, and Canada is a signatory. But in Canadian provincial law, and I will agree to this, that it generally means the decisions about the issues of child's related to guardianship, parental responsibilities, parenting time, when the child can decide something on their own, relating to the level, stage of maturity, etc. But," and she goes on, "I think it is critically important that privacy is a fundamental right, and special protection for children's and minors' rights is referenced in the preamble, because the bill," and she goes on, "the bill also mandates that children's data must be considered sensitive data, and that is very important and impactful as well." So the Privacy Commissioner of Canada recommended that we include the best interest of the child in the preamble, which he also recommended be included in the body of the bill. The former Privacy Commissioner of British Columbia and one of the leading global experts recommended that we do that as well. But they're not coming from nowhere on this. The OECD, in fact, which Canada is a signatory to, has a recommendation on children in the digital environment. Canada is a signatory to this document. I read it today during question period. They said it's called the Recommendation of the Council on Children in the Digital Environment, and it's an OECD legal instrument document. And in the document, they speak about the best interest of a child. This is a legal international document that Canada has signed, and they recognize, the OECD, that Canada is a signatory to, that the digital environment is a fundamental part of children's daily lives and interactions in a number of contexts, including formal and informal education, formal and informal health services, recreation, entertainment, maintaining links to culture, socializing, expressing themselves and their identity through the creation of digital content, engagement with political issues, and as consumers. And they recognize that children's capabilities vary by age, maturity, and circumstances, and that actions and policies for children in the digital environment should be age appropriate, tailored to accommodate developmental differences, and reflect that children may experience different kinds of access to digital technologies based on their socio-cultural and socioeconomic backgrounds and the level of parental, guardian, and career engagement. And they also recognize that safeguarding children's privacy and protecting children's personal data is vital for children's well-being and autonomy and for meeting their needs in a digital environment. That document also references the UN's rights in the digital environment for children, which states that the best interest of the child is a dynamic concept that requires an assessment appropriate to the specific context. And what we're doing here, and what the sub-amendment doesn't accomplish, is that it doesn't allow for that very specific language that is well defined, that in documents Canada is a signatory to, including the OECD, the G7, which I will get to, as well as other various state American laws that I will touch upon too. The UN states that state parties should ensure that in all actions regarding the provision, regulation, design, management, and use of the digital environment, the best interest of every child should be a primary consideration. So Canada is a signatory to that document as well, where they outline it. I'll just go back to the OECD for a second. For their guidelines for digital service providers, which aims to support digital service providers when they take actions that may directly or indirectly affect children in the digital environment, in determining how to best protect and respect the rights, safety, and interests of children, recognizing that girls, children belonging to racial, ethnic, and religious minorities, children with disabilities, and others belong to disadvantaged groups may require additional support and protection. And that document states that to limit the collection of personal data and its subsequent use or disclosure to third parties to the fulfillment of the provision of the services is in the best interest of the child. Again, Canada is a signatory to that document. Internationally, there was a resolution by data protection authorities from around the world on children's digital rights, and that was signed by Canada's Privacy Commissioner as well. And that states, affirming that in the implementation of policies relating to the rights in the digital environment, taking into account the evolving capabilities of children and their best interests must be a primary consideration. I'll go on. France, a trading partner of Canada's, their commission outlines, and I quote, in order to support young people, parents, and professionals develop a digital environment that is more respectful of children's best interests, the CNIL has published 8 recommendations stemming from a review conducted with all stakeholders concerned. So France and their laws recognize the best interest of a child. Ireland's data commissioner has a core message that the best interest of the child must always be a primary consideration. But one which is very, very important is the G20 digital ministers call for actors involving in the digital environment to uphold the child's best interest. So Canada is a signatory to the G20, outlines that the best interest of the child in the digital environment must be taken into account of our policy development and our legal rules. So that's in response to what you just said. But what do you feel about, Mr. Shan or any other department officials, is California an important trading partner for Canada?
I think you'll find from the statistical data on trade flows, yes.
What importance does California have in the development of technologies that might be applicable to Bill C-27?
I think that, Mr. Chair, I'm not sure I'm in a position to offer all of the ways in which California is engaged in technological development, but I'd say that obviously they're a tech center.
Okay. From what I understand, and I think you would probably agree with this, many Canadian companies in the tech sector do business with tech sector companies in California. Is that a fair assumption?
Again, I'd say California is a locus of activity related to the tech sector. Insofar as Canadian companies do business with them, I think that would vary. But
okay, in California, Mr. Shan, through you, Mr. Chair, there's called the California Age Appropriate Design Code Act. In that act, it states very clearly that if a conflict arises between commercial interests and the best interests of children, companies should prioritize the privacy, safety, and well-being of children over commercial interests. This is in the law that governs the largest economy in the United States. This is in the law where more technological development takes place anywhere in the world, and I am still at a loss why the department would state that the best interest of child is a subjective construct. Please answer.
Mr. Chair, I hope I've been clear that I think our considerations and commentary on the record are that in a commercial context, the interpretability of this term may pose challenges for implementation by corporate entities in terms of their understanding. So I think we've spoken to the fact that the established tests to be able to understand that at the part of courts or parents are important considerations, but that as it relates to the commercial context, that there may be better ways at being able to express the exact same concern about the stronger protections required.
Mr. Chair, we did not hear from a single witness that disagreed or did not believe that the best interest of child was a concept unworthy of being in this legislation. Throughout the initial parliamentary debate and everyone we've heard from so far, it's been very clear that in this changing and dangerous digital landscape, that we have to protect children. And in my meeting with the Privacy Commissioner yesterday, he very clearly stated that the adoption of this sub-amendment would reduce his ability to do his job and effectively enforce the protection of children's privacy rights. I'll also mention that I reached out to Mr. Michael Beauvais. He was another witness, and along with Professor Leslie Regan Shade, they said in response to the proposed sub-amendment, the overreaching problem with the proposed sub-amendment is its narrowness. Children are citizens and are more than just economic actors. Not mentioning the best interest removes an important tool in the regulator's toolbox to develop guidelines or regulations dealing with minors. The proposed sub-amendment suggests that minors' information is only worthy of increased protection because of their varying levels of capacity to understand, in brackets, how their personal information is used by organizations, and the use's long-term implications. It may lead, he goes on to state, to an interpretation that minors with capacity merit less robust protections. Even educated adults experience difficulties in understanding how organizations use their personal information, especially in big data context. He goes on, moreover, focusing on children as participants in the digital economy, as per the department's view, those are my words, takes too narrow a view. For example, the bill would apply to Indigenous bands regulated under the Indian Act. This is currently the case with the Personal Information Protection and Electronic Documents Act. While this is part of a broader issue, the draft language exacerbates the framing of individuals as consumers and economic actors. Let me just state very clearly, the Conservatives' position is that my job is to protect children, and I believe that's the same objective of everyone around this committee table. I, in good faith, looked very closely at the sub-amendment, and I cannot, in good faith, support this measure in its current form. We have to include the language of best interests of children. There is too much at stake that we don't understand. Before continuing on, I know I've been going on for a while now. I will note, and I'll just re-emphasize that in the first recommendation from the Office of the Privacy Commissioner, he requested that we put the preamble into the body of the bill. There was also concerns raised regarding the reference to artificial intelligence. When this bill was created, and yesterday we had some on Monday we had some semantic arguments about Schedule 1 and Schedule 2. We're not going to repeat that, Mr. Chair. But it kind of reminded me of my catechism class as a young man when we learned about the Holy Trinity, 3 in 1, 1 in 3, one being the same, consubstantial, begotten of the Father, not made. Francesco probably went to the same classes as me. This is like the Holy Trinity of digital bills. It's 3 in 1, one and the same. 3 are different, not the same, but all together. It's confusing, Mr. Chair. I am really confused, and I know some of the terms of the titles refer to acts, but they are in fact all 3 bills: 1 in 3, 3 in 1, one in the same. And I know Mr. Shan's having a good chuckle about that as well. So I will stop there for the moment. I believe I'm going to stand by the recommendations of the Privacy Commissioner in good faith, and I look forward to further debate on this sub-amendment.
Thank you very much, Mr. Viss. Mr. Perkins, and then I have Mr. Massé, Généreux, Turnbull, and Garon.
Thank you, Mr. Chair. I'm out of breath.
Well, and how do you think the translators, the interpreters feel? So on that note, Mr. Perkins, because we opened that door, Mr. Viss, if you can speak a little more slowly going forward, especially when you read.
I had over 10 pages of notes.
It's appreciated, but for the interpreters, Mr. Perkins.
Yes, Mr. Chair.
Thank you, Mr. Chair. If I could take just a brief step back on this, and I want to acknowledge MP Turnbull's proposal to try and find a way to put CPC1 and NDP1 together, and acknowledge your opening remarks of saying that you're supportive of the idea of the preamble going into the legislation itself. So I want to thank the government for a genuine effort, I believe, to try and do the overall statement. And I on the actual proposed sub-amendment, that's the right term. I don't know, it says Mr. Gahir, but I think it's in your name now. I don't know if it's in Mr. Gahir's name, but our discussion here isn't about what would be, I think, C in this, which is C and D, which I think is the issue of the problem with the references to the Artificial Intelligence Act and the and bringing in MP Massey's an element of his amendment. I think I don't have a problem. We have total, I think, agreement with that. I think as MP Viss just pointed out, we're struggling with the loss of what we think is a very important concept in the best interest of the child. So I've got a couple things I'd like to ask questions about, and one thing just to make sure everybody's, but I guess, Mr. Chen, or Ms. Angus, I don't know who's the appropriate one on this. Just to take a step, what we're talking about here is that the idea of the best interest of the child was stated in our discussion of these amendments last thing is a subjective construct. Now, that's a legal term, right? So I'm wondering if you could explain that for everybody who's watching to know why we're having this discussion, what a subjective construct is in terms of looking at legislation.
Chair, I'd offer that for the purposes of our considerations and much of what we'll likely offer as responses to questions over the course of the consideration of this bill is the interpretability of its implementation, which is to say that we are deeply motivated by ensuring that this bill can be understood and held accountable to the corporations of all sizes who use personal information in the Canadian context will be able to live up to it. And so from our perspective, I think our considerations and comments were in relation to the fact that for the purposes of the implementer, the corporation who needs to make a determination about the use of personal information, who are not necessarily afforded the efforts of a family court or have not sat and presided over significant kind of amounts of cases where this is their bread and butter, that being clear about the stronger protection required for minors' information is what we saw as pivotal to relaying, and hence our comments and considerations.
So, in other words, the term, if it was put in this bill, the best interest of the child, without some mechanism for defining what that means, would rely on the courts to interpret and companies to interpret what Parliament's intent with that was, because there is or there is not adequate case law to define that with regard to best interest of the child and privacy.
I think we'd imagine this would probably be a zone that the Office of the Privacy Commissioner would probably seek to issue guidance. We imagine that this would be a zone where there would need to be further guidance, either through jurisprudence or through the OPC, to aid commercial entities in understanding how they should interpret the best interests of the child for the use of personal information in the commercial context. And so this would apply, as this bill does, to every commercial entity operating with personal information in the country. And so all of them are going to need the capacity to be able to know what to do with minors' information, and to be able to understand their obligations. And so hence that's our interpreting frame. So yes, I think the answer to your question would be there will need to be some meat put around this, which will probably borrow from much of the case law that was cited by the honourable member and other instances to try and translate it into the real implications for a commercial entity in their transactions related to the personal information of minors.
So we had some lawyers. Not a lot, thankfully, but we had some lawyers appear before the committee on some of these things. Sorry, Mr. Gear. We had some lawyers appear not related to the bill in general. And with regard to another aspect of it, when we were discussing, I think it was around the terminology of legitimate interests and those things, they actually said there was case law around that definition, but not in Canada. In other countries, that courts would turn to as well in looking at that. So MPVIS went through, a law and presumably case law in other countries around best interest of the child. So doesn't that help already in guiding, say, the corporate legal counsels advising people like me that were in the marketing field in large corporations on what we should and should not do, and whether or not you had a internal privacy watchdog or not within the company. It doesn't just have to be Canadian case law, does it, in order to provide definition to best interest of the child?
So I think some measure of OPC guidance, international best practices can afford corporations in a number of these spaces the capacity to be able to know how and when to interpret its obligations. And I think international case law can be useful, but obviously always needs to be brought back to the kind of crux of what is their legal regime, what is their overall system, how similar or non-similar is it to ours, what obligations do they or do they not possess in terms of their authorities. There's a number of those questions, but certainly if I was an entity looking for inspiration as to how to start to interpret it, those would be amongst my places. But
I'm not going to get into the Schedule 1, Schedule 2 thing again, but I am going to make a reference to another section, if that's okay, which is Clause 122, in particular 122E, which is the clause that deals with the regulatory power of the governor and council. And basically it gives the governor and council the ability to make regulations with respect to this bill or this act, the replacement of the Privacy Act, on some very specific things in A, B, C, and D. But in E, it also says prescribing anything that by this act is to be prescribed. So if the preamble is now part of the opening of the bill as opposed, and therefore has some legislative and legal interpretive weight, does that not give the governor and council the ability to use regulation to provide some legal fence posts around what the government would see as the best interest of the child out of the starting gate?
Just a quick point of order, Mr. Chair. Do you have that page number?
Yeah.
60,
it's,
thank you.
61.
Thank you. Thanks.
Thanks.
Thank you, Mr. Chair, for the question. I've had enough correspondence with the Standing Committee on the Scrutiny of Regulations to know better than to provide a definitive answer to Mr. Perkins as to whether or not the regulation-making authority in E would compose sufficient room to issue regulations on the basis of the preamble. But to say likely not, because normally a statute needs to indicate that regulations are to be prescribed or use terms like a prescribed entity, and then you draw on the power of E to say what those prescribed entities actually are. As I say, I'm not gonna be definitive, but all that to say is, if this term ends up in the preamble, as I've noted, it's the likely space by which OPC guidance would probably be forthcoming.
So in a number of areas that the Minister of Innovation, Science and Industry oversees and his responsibilities, he has issued policy directives. I'm thinking of things around Investment Canada Act. I'm thinking of things already around artificial intelligence, for example, and codes, voluntary codes. When this becomes, if this amendment passes and becomes law with the term best interest of the child, and if you believe, and the lawyers believe that you can't use Section 122 to define it under regulation, can you not provide some similar policy guidance for companies and anyone else in the public that wants to understand where the government sees the fence post being on this definition? I know it doesn't have the same legal standing, perhaps in court, but it provides a sense of guidance and intent, does it not?
We have the interpretive authority of the CPPA will be the same as the interpretive authority of PIPEDA, which is the interpretive authority, is the Office of the Privacy Commissioner. They hold the capacity to interpret the statute as enacted. There is a capacity for the minister proposed under the CPPA to ask the commissioner to issue guidance and to take up this particular any particular issue as it relates to issues of import related to the interpretation of the Act.
Well, that's interesting. So in other words, you can issue guidance, not necessarily the government, the privacy commissioner, and that brings me to the document that MP Viss referenced that was issued on October 4th and 5th, the conference, the 2023, signed by the federal and provincial privacy commissioners. It's on the website of the Office of the Privacy Commissioner of Canada. And just so for folks who are watching, and I know there are a lot of people watching this because we get emails and texts and phone calls after every meeting about what we got right or wrong too. There seem to be a lot of lawyers, all lawyers watching this. I'll start. It says I'll start just and say that the opening of it is called the context. So what it says is Canada ratified the United Nations Convention on the Rights of the Child. Then there's a long URL that links to it in 1991. That would have been by the Mulroney government. The UNCRC affirms children's rights, including the right to privacy, and introduces the concept of the best interests of the child. The concept implies that young people's well-being and rights be primary considerations in decisions or actions concerning them, directly or indirectly. As a guiding principle, this concept can be applied in a variety of contexts to help assess and balance the interests of young people against others. In over 30 years, the UNCRC has had a tremendous influence on young people's rights around the world, including privacy. Many jurisdictions have recognized that young people may be impacted by technologies differently than adults, be at greater risk of being affected by privacy-related issues, and therefore require special protections. Some of the most authoritative and current policy and legal instruments that focus on or include provisions for young people's right to privacy are, and there's a list of them here, I won't go into the URLs, but the UN General Commitment number 25 on children's rights in the digital environment, which supplements the UNCRC. The next one is the OECD. I think my colleague referenced that, the Organization for Economic Cooperation and Development, of which Canada is a member. A Council recommendation on children in the digital environment. There's a URL link. And there's another OECD document called Guidelines for Digital Service Providers. It goes on. There's another reference, the Age Appropriate Design Code, which is on a children's code, obviously created by, that you're aware, the UK Commissioners, the UK Information Commissioner's Office. There's a resolution on data protection authorities from around the world on digital rights. France's Commission Nationale de l'Informatique et des Libertés, excuse my French, I'm working on it, recommendations to enhance the protection of children online. Ireland's Data Protection Commissioner's Fundamentals for Child-Oriented Approach to Data Processing. Then, as my colleague Mr. Viss referenced, the G20 digital ministers call for actors involved in the digital environment to uphold the child's best interests. The next document they reference is the California Age Appropriate Design Code Act, and then the EU Digital Services Act. It goes on to say these initiatives and many others recognize that the digital environment presents many opportunities for young people, but they also are a necessary response to the well-documented harms to young people, such as mental health-related harms. These initiatives are promising, but the signatories believe that there is still work to be done in Canada to ensure that young people are protected from these harms through legislative measures to make their best interests a primary consideration in the design of products and services that concern or impact them. Therefore, the next section, Canada's privacy commissioners and ombudspersons with responsibility for privacy oversight call on the respective governments to put the best interests of young people first by taking immediate action as necessary to, and it's a series of bullets, protect young people from commercial exploitation and the use of their personal information to negatively influence their behavior or cause them harm. Next point, to promote the privacy rights of young people. Review, amend, or adopt relevant privacy legislation to be consistent with internationally recognized policy and legal instruments to ensure adequate protection of the privacy rights of young people. And the final bullet, require private sector organizations that collect, use, and disclose the personal information of young people to implement strong safeguards, be transparent about those practices, and enhance access to effective remedies for young people. The signatories recognize that the privacy rights of a young person are their own rights. Any limitation to their exercise, e.g. vis-a-vis parents, guardians, or public bodies, must start from that principle, be specific and limited to the particular circumstances, and be consistent with the best interests of the young person. The signatories also recognize that privacy rights apply both within and outside of their digital environment. While this resolution mainly focuses on the digital environment, its principles should be broadly applied. The signatories highlight that young people's personal information is particularly sensitive. The bill addresses that with the definition. Any collection, use, or disclosure of such information must be done with this in mind. The signatories recommend that public and private sector organizations adopt the following practices, which also reflect principles that should guide legislative reforms. 1, build in young people's privacy and best interests by design. Digital privacy risks to young people should be identified and minimized as early as possible. Organizations should ensure that privacy and best interests of young people are built into the product or service right from the design stage. Organizations should conduct privacy impact assessments for projects involving the data of young people or to examine the specific potential impacts on them. Adopt their traditional PIA process to think specifically about the perspectives and experiences of young people as individuals and as a group before collecting, using, or disclosing their information. And I know that the officials are very familiar with this, but I'm not sure everyone who is watching is. So the next point on what organizations should do is that they should actively involve young people, the parents, guardians, teachers, or child advocates in these assessments, and conduct intersectional analysis to consider specific privacy risks to vulnerable groups of young people. For example, those with disabilities, First Nations, to SLGBTQI plus, two-spirit, lesbian, gay, bisexual, transgender, queer, intersex plus people. Section 2, be transparent. Transparency is necessary for informed decision-making and consent. Organizations must provide privacy information to young people and their parents and guardians as appropriate in a concise, prominent, and clear manner suited to the maturity of the young person. They must inform young people of who to contact if they have questions about information presented. 3, they must be transparent about the privacy risks associated with using their products or service. This could include information on their special efforts to protect young people from these risks. 3, set privacy protective settings by default and turn on tracking and profiling, and there's a whole list of things there. 4, reject deceptive practices. These things include things young people must not be influenced or coerced into making privacy-related decisions contrary to their interest. Organizations must not incorporate into products and services manipulative or deceptive design or behavioral incentives that influence young people to make poor privacy decisions or to engage in harmful behaviors. Encourage young people to provide more information than what is necessary to use the product or service or to turn off protected privacy settings. Organizations should design products and services intended to empower young people to make informed privacy protection choices and take assertive action to advance their privacy and transparency limits. There are a few other ones. Limit the disclosure of personal information. There's some more guidance for organizations. 6, allow for the deletion or de-indexing and limitation on retention. Again, more guidance for organizations. 7, facilitate access to and correction of personal information. And in that, it says young people have a right of access to their personal information. That right is fundamental to ensuring that the information is accurate, up to date, and retained for appropriate purposes. The right of access also serves to hold organizations accountable. All organizations have a general legal responsibility to provide timely and complete access to young persons' personal information upon request from that person, and in most cases upon request from their parent or guardian. It is recognized that a parent or guardian's access to information may be limited by a young person's privacy rights as is qualified by the individual's best interests and dependent upon the particular facts in each case. It goes on to describe more responsibilities for an organization and has a number of footnotes and reference, and you can see the logos of all the various privacy commissioners are on there. So you said you expect that the privacy commissioner might issue guidance and that he or she has the ability under the Act to do that, and that would probably be of more value, or that would be the appropriate route. But the privacy commissioner has already done that. That looks pretty specific to me. Now, he could reissue it under the power, I guess, once this bill goes, but it's pretty specific guidance right now. I don't know how an organization in Canada wouldn't understand the guideposts that have been set out. They're very detailed and clear in this. Perhaps the privacy commissioner would provide even more detail if this provision on best interest of the child is passed. But to me, I'm struggling, as my colleague MP Viswas, with the claim that it's subjective. It doesn't look subjective to me. It looks very specific that privacy experts have defined this very well. So we struggle with the idea that the removal of that term is something that the government wants to do, rather than provide that term in legislation for not only the courts to interpret, but as you pointed out, to allow the privacy commissioner to give very specific guidance if he thinks it needs to be more detailed than this, under this Act. But without the term best interest of the child in the Act, it's difficult for the privacy commissioner to provide that legal guidance that you referred that he has the power to do on that terminology, is it not?
Thank you for the question, Mr. Chair. I think the goal of providing guidance on stronger protections, I think, is what we imagine the privacy commissioner would rely on.
So, would the privacy commissioner, how can the privacy commissioner issue guidance on best interest of the child if that's not the terminology in the Act? Because he can't issue guidance on something that doesn't exist in the Act.
What I'm indicating is that the general construct of the stronger protections for minors would both be elucidated through the specific obligations that are actually contained in the CPPA, and then would be the subject of guidance in terms of actual implementable capacity for an organization. So not just the sort of general value of the best interest of the child as an interpretive frame, but the actual specific ways in which an organization would be able to draw on that in making a determination, for instance, on a disclosure of personal information or a specific use of a piece of personal information.
The department or the minister talk to the privacy commissioner about this proposed change to our amendment before tabling this proposed sub-amendment?
We've had an ongoing dialogue dialogue with the Office of the Privacy Commissioner as it relates to this bill, including the government's potential areas for amendment.
Well, in our discussion with the Office of Privacy Commissioner yesterday on the specific wording of the bill, he has a different view than you just articulated. He said it actually narrows his ability, the Privacy Commissioner's ability, to actually issue guidelines on best interest of the child. Not using that terminology restricts his ability to provide guidance to organizations on that concept without the words "in the Act." And I'm assuming the department's saying you don't agree, that it doesn't restrict it?
I think our view is that the appropriate considerations that we're looking for are around the ways in which organizations can provide stronger protections for minors. And so I don't hold a specific view on whether or not this does or does not do that in the specific ways that have been articulated.
I was almost finished till you said that. Sorry. Sorry. And I'm not, this isn't, obviously, this is not a political discussion. This is a very specific thing that some of us who are marketing guys are trying to, we look at words differently than lawyers do. So, but when the department and the department's extensive lawyers, I presume the Department of Justice is part of looking at these things, decides to remove those words of best interest of the child and replace it with other words, they were trying to do so for a specific intent. And in the Privacy Commissioner Office's opinion, that specific intent is to narrow his scope. What was, if you don't agree with that, then what was the specific intent of removing the words best interest of the child and replacing it with language that other lawyers think narrows the scope?
The specific intent of the sub-amendment was to, in the absence of already issued guidance or guidance still to come, provide interpretability to commercial actors that would need to live up to this ambition from the moment of promulgation. And so the intent was to provide them with a clearer pathway towards living up to the Act, noting, as we have, that this inclusion would require further guidance.
So the words that you're proposing here, that the government's proposing here, aren't enough to provide the guidance. Something else will have to happen.
So the words that we've provided in terms of worthy of stronger protection are consistent with the obligations that are found within the CPPA, notably this sensitive definition of information as it relates to the information of minors.
But it doesn't reflect the language of the many documents I outlined and MP Viss outlined that the Government of Canada has actually signed in accepting that our legislative frameworks should reflect the terminology that has been negotiated internationally, whether it's OECD, G7, or the UN Convention, that use the terminology best interest of the child.
I think the declarations outline the intent to get to an outcome of stronger protection for minors. And we believe that to be consistent with those declarations.
Then that terminology should be in the bill. If it's worthy of Canada signing it, then why isn't it worthy of Canada putting in the bill?
Mr. Chair, I don't have a response to that.
Okay.
Fair enough. Thank you, Mr. Perkins. I have Mr. Massey on my list.
Thank you, Mr. Chair. I'm going to try. First of all, Mr. Shannon, as a former vice chair of the Scrutiny and Regulations Committee, me and maybe about 3 other people got your joke. So one of the most obscure committees in Parliament and so forth. But at any rate, and I do appreciate the government bringing forth this amendment. It's clearly to try to address Conservative and an NDP amendments that are very similar. But what I'm worried about is whether this seems more like a political compromise that then could very much, unfortunately, fall short for the legislation at the end of the day. Are you familiar with the UK's legislation? That's one of the things I would like to know, if you're familiar with the UK's legislation and what they've done with children in theirs.
I think if you're speaking about the design code for children, then yes.
Yeah, so, under the UK Data Protection Act, they have, and I won't read the whole sections for it, but they have really a robust section. They also talk about, how children change over time as well, too, and so forth, and other anomalies with it. Would you say that this amendment, or even what we've offered before, is stronger or weaker than the UK's protection of children in terms of what we have in front of legislation? Do you have an opinion as to that?
So I think the amendment we have before us is a preamble to the bill. If you're asking me about the bill itself and its actual obligations on entities as to their treatment of personal information, I would say we would suggest that the CPPA, as proposed, with a number of amendments that might follow, will allow for commensurate degrees of protection for children